Is this audible, Your Honor? May it please the court?
You may proceed.
And counsel? Your doubts are reasonable. Your doubts are reasonable because Jim did not kill Molly. Your doubts are reasonable because, as I said from day one, the state will have to get back up here and ask you to fill in the gaps because they do not have evidence to prove this case beyond a reasonable doubt, and that is precisely what we just heard. What do we know? Yes, we heard much testimony. We heard several witnesses, several exhibits. Yes, Jim had an affair. Yes, he had 2 different long-term relationships. And we have pictures of both of those relationships in the evidence. The relationship with Molly, the evidence shows love notes, pictures of vacations, thousands upon thousands. Those were the words in testimony. Thousands upon thousands of text messages. And the state of Missouri picks out a couple dozen and says, let's guess at what these mean. Fill in the gaps for us. The other relationship with his wife, yes, he was married, we get that, was strained. Arguing about money. Melanie Addie testified she thought they were working on it. No evidence of love and affection in that relationship. Nothing like with Molly and Jim. Keep in mind, Jim is not on trial for adultery. Yes, he had an affair. An affair does not make one a murderer. Yes, we heard from Ms. Cohen, the wedding planner. Yes, they cut a guest list. Yes, obviously, Jim was already married. But her word was wedding planning went perfectly. That's what she said. And if Jim had a decision to make, he goes in, and you heard from Ms. Cohen, pays $4,000. Pays $4,000 on his credit card, when, as we heard, his wife is concerned about the finances, they argue about money. Obviously, she's going to find out. Who else do we hear from? Yes, we hear from Mr. McSparron, who doesn't know what he saw. At first, he thinks he saw an SUV or a truck with a camper. Then he says a vague description of a car, but also that he couldn't make it out because he was blinded. Again, blinded was his word. And the state just tried to outline a timeline, but again, they're asking you to fill in gaps because what you don't see on that timeline is when Mr. McSparron would have come across whatever car it was out there that he came across. 911 call was 10:06. He was coming from less than a mile away and had been there for 20 minutes. Remember, he said he was tired, so he wasn't there long. Maybe 20 minutes. The timeline the state just put right up here is false. They are asking you to fill in the gaps. Sergeant Ream said it's a 30-minute drive from that scene to Jim Addie's house. And you heard from Emma Addie, who did not say that 9:50 was the time Jim first arrived home. Even if you fill in the gaps that much for the state, that still doesn't make sense with the state's own timeline. But what she said is that's when he came in the door. There was no testimony that she saw headlights pull in the drive, heard a car shut off, heard a door shut, then Jim walks in. No. Her and Melanie both agreed it was not unusual for Jim to spend time in the garage. It was not unusual for Jim to work on cars in the garage, that he did those things frequently. And when the police ask where the car is, that he tells them he was driving that evening, he says it's in the garage with the hood up. Emma also says nothing he did that night was unusual. Doing laundry, not unusual. Bathing, not unusual. In fact, the state asks you to think he commits this crime, throws evidence out the window, so throws a t-shirt out the window, but goes home to do laundry to cover his tracks, but leaving literal tracks? Well, which is it? What sense does this make? Absolutely none. What they are doing is asking you to fill in gaps for which they cannot provide evidence. For example, we just heard that this low water crossing we've heard so much about was not some place you go for a leisurely drive. Where is that in evidence? This is not a place you go to do business. Where is that in evidence? Who she trusts enough, what she's wearing when she leaves the house that day, where is this in evidence? You are to make this determination on the evidence the state presented, and they are standing here saying, just assume all of these things. The phone calls we just heard about, a 2-second phone call, a 3-second phone call, well, that's not even enough time for voicemail to pick up. That's not in evidence, but also we all know call logs start counting once voicemail does pick up, right? And again, officers come to Jim's house and we're told that these ambiguous text messages are an attempt to establish an alibi, and yet he is upfront. You heard Sergeant Ream testify about this. He was upfront with the fact that he had 2 cell phones. He was upfront with the fact that not only did he have an affair, but this other cell phone is solely for that purpose. And now we're told he was misleading them so he could try to set up an alibi? here are the two phones, and that's misleading? During that conversation, we have no evidence that during that conversation there was anything misleading about the content of the conversation Jim and Molly had, that officers asked about her trip. That's what you heard in the state's argument, that he was misleading about the trip that she took. That's not in evidence. There was no testimony about that. This is what I mean by the state needs you to fill in the gaps. This is not proof beyond a reasonable doubt. They're also asking you to fill in gaps about an obviously important piece of evidence. They're saying that the murder weapon, whatever it is, must be Jim's, except is it the one that was left at the back door in plain sight when he welcomed officers into his home, that tested negative for blood, that tested negative for DNA? Is it that one, or the one that we heard about for the first time at trial, where Melanie Addie says, oh, there's a missing gun, that, by the way, none of the law enforcement officers we heard testimony from testified, we're investigating to try to find this missing gun because we think it might be relevant. No investigator testified about trying to find such a weapon. Because there wasn't a missing gun from the nightstand. And then we have an ethereal reference to, at some point in the past, there may have been a gun in the glove box, except we can't identify it, describe it, or even know when that may have occurred. Again, do not fill in the gaps. These things are not in evidence. And again, we hear about the T-shirt, the ammunition box. The ammunition box, by the way, that is not tied to Jim at all in any way. I don't know how many people hunt down that road, hunt in that area. We can't limit that. I don't know how many addresses are within X number of miles of that road. Nothing ties that ammunition box to Jim. Again, asking you to fill in gaps. The shirt. Yes, we actually heard real science about what was on the shirt, except is it so implausible that one fiance has a shirt that belonged to their fiance? And if they're saying that he's trying to rid the area of evidence, then things like the marriage license are left behind? In what way does this make any sense? We also heard argument on the defendant being misleading about what he was wearing. Well, in what way do we know he was being misleading? Where is that in evidence? You heard Sergeant Ream say that Jim told him what he was wearing, and Sergeant Ream said, nah, I'm not going to seize it because I'm just going to make up my mind and decide not to believe you. And then later on I can say, well, I didn't seize it because it wasn't true. Well, we don't know that. More filling in gaps. You heard talk of boots and a jacket. And I asked about the boots and the jacket in Defendant's Exhibit B, and we heard nothing more about it. Sure, there are jackets and boots in this picture, but no, I didn't really look into it. And mind you, that photograph was in evidence when both Emma and Melanie testified, and no one mentioned the fact that there were jackets and boots that were left behind, that were not investigated. You also heard from Misters Hendren and Painter. We heard much to do about how Jim was allegedly too quiet, and yet these two state's witnesses come in here saying he couldn't possibly have been more talkative. In fact, having never met him, none of them having ever met, he just up and confesses to a crime to two random guys in jail. This alleged statement, by the way, doesn't match the facts from the scene. Let's not forget that. Mr. Painter says, we were in a small room, all sitting on the couch. Mr. Hendren says, wide open bay. We were 10 feet away. And sure, there was background noise. I think that's what I heard. But now we're sure of it. And yeah, we talked about it before going to law enforcement to tell them what we heard. But we definitely heard it independently and didn't really talk about the content before we went to law enforcement. So what really happened that night? We don't know because there was no proper investigation. They saw Jim was already married, saw that he had another wedding planned, and they made up their minds. They jumped to the wrong conclusions. Despite the fact that he cooperates, despite the fact, again, welcomes law enforcement into his home, talks to them, shares the cell phones with them, shares what he did that evening. Mr. Lunsford testified that Jim was right. He wasn't home that night. And that leaves us with the forensics. Remember the DNA that was taken at the scene excludes Jim, but includes other unknown people at the scene. Jim's DNA, not on the shirt. Again, the 22, no blood, no DNA. We have, sorry, I don't know what noise I just heard. We have gunshot residue testimony. Again, the state having it both ways. Jim has guns at his house, shoots guns. They put in evidence his military service, and yet one single GSR particle, gunshot residue particle, is supposed to tie him to a specific shooting. One gunshot residue particle that can stay on a surface forever. I would be shocked if half of the cars in Missouri didn't have at least one gunshot residue particle. And then we have Mr. Crafton and what we were told would be perfect tire print. And what we're still being told is science, that it's very precise, that it's peer-reviewed and validated. Except when I ask questions about, say, peer review, and the Highway Patrol, keep in mind, he used that phrase to mean two different things. So there's peer review in the scientific literature, which is how real science gets published. And then there's peer review, which is what they call it when somebody he works with says, yeah, I think you got this one right. Those are two different, very different versions of peer review. So we're told it's scientifically validated. We're told there are articles. We're told there are peer-reviewed articles. And then when questioned, and the state says, what do those articles say? Well, I can't really recall. That's what we were told. Do we know any real scientific standards for this endeavor? No, we do not. Do we know any real scientific criteria for this endeavor of comparing a tire and a dental stone cast and coming to the conclusion that, yes, this tire must have made this cast? Do we know the scientific criteria for that? No. Do we know any guidelines, policies, any objective standards that one has to apply in order to make that determination? The answer is no. The answer is no because A, it's not science. B, the criteria we're told is that it is up to the examiner themselves. A science in which the standards to apply are up to the scientist in the lab. Literally unbelievable. But okay, I tried to go with it. Let's try to apply whatever it is he applied. So what is he looking for in making this comparison? Class characteristics, we get that. The manufacturer meant them to be there. What it really boils down to are what he referred to as individual characteristics. The results of normal wear and tear. So I asked things I would think are relevant to normal wear and tear. He has no idea about how these tires generally wear and tear. But we're told that doesn't matter because it only matters this one tire. Okay, let's use that. Individual characteristics from this one tire. We are told these are measurable features, including location, shape, and features of imperfections. And I say, all right, let's start with number one. You have 11 such things that you are claiming says this tire, not any other tire in the world, made this cast, made this impression from where we get this cast. So let's start with number 1. Location, shape, features of the imperfection. Oh, well, I don't have that. I don't have measurements. I don't have anything where I can actually identify that sort of thing. I just put them side by side and said they were in the same approximate area. I didn't want to get the quote wrong. And when I asked that he came before you as an expert and asked him to explain a single finding, he said, I wouldn't venture to do that here. Measurable features. Measurable features to limit a tire print down to 1 tire in the entire world, and he didn't bother to measure one of them. This is not science. We heard DNA evidence to a degree of certainty of 1 in 8 point something nonillion. I had never heard that word before, but nonillion is 1 with 30 zeros behind it. That is a science. And we know with that same degree of certainty that whatever Mr. Crafton does, it is not science. And with all that said, this is why your doubts are reasonable. Your doubts are reasonable because Jim did not kill Molly. Your doubts are reasonable because Jim wasn't there. There is no doubt that this case resulted out of a horrendous tragedy. But don't multiply the tragedy by sending an innocent person to prison forever. This is the hardest part of any trial for me. Because I'm about to sit down and I will not get a chance to speak with you again. The state gets to. I don't get another opportunity. And I have been, in this case, living and breathing it with Jim for a long time. And to a certain extent, he's been in my hands. And when I sit down, I put him in yours. And I am reminded each and every time of Thomas Jefferson writing to Thomas Paine about trial by jury. Jefferson wrote, "I consider trial by jury the only anchor ever yet imagined by man, by which a government can be held to the principles of its Constitution." And I ask you to be the juror who holds the government to the principles of its Constitution and say, I will not fill in the gaps. This evidence is not beyond a reasonable doubt. And Jim is not guilty.